We discussed among ourselves at lunch. Initially, my brief was to confine to 11.6a, but to save time, I think Jayant Mehta and Nikhil will deal with section 8 and 9 and stamp back notes, so that they can argue.
Thank you very much.
Very grateful for appreciating hearing all your lots of time.
Now I'm going to make 3 or 4 submissions. The first of it is without, and I'll straight away formulate it without wasting much time because the Lordship knows the background. The first of it is that the arbitration agreement.
Just one second.
Sorry. Well, my first submission is that the arbitration agreement is not chargeable to stamp duty. Because the original question, which was referred to the 5 judges, if my Lord just has a look at the original question that was referred to the 5 judges, and that is at page 293 of volume 5A, which I submit was the correct question. Page 293, volume 5A, which I submit was the correct issue. Paragraph 58. We consider, may I read it?
Yeah.
We consider it appropriate to refer the following issue to the authoritative settled by a constitution bench of 5 judges. Whether the statutory bar contained in 35 of the Stamp Act, applicable to instruments chargeable to stamp duty under section 3 read with the schedule of the Act, would also render the arbitration agreement contained in any such instrument, which is not chargeable to payment of stamp duty, as being non-existent, unenforceable, or invalid, pending payment of stamp duty on the substantive contract instrument. This was one of the original questions.
These words, Mr. Safedande, which is not chargeable to the payment of stamp duty, does that postulate that an arbitration agreement is not chargeable to stamp duty?
Yes, Milord, that would be my submission. And Milord, what happened before the 5 judges is.
But did they
reformulate? I want to read
the question
on the basis of a concession made. The reformulated question, if I may just pose for your Lordship's consideration, is at page 352 of volume 5A. And I'll just make 3 short propositions on why it is not chargeable to stamp duty. Page 352, volume 5A is the reformulated question based on the concession by the amicus curiae, learned amicus curiae. Paragraph 32, Milord. May I read it? In view of the submission made by the learned amicus curiae, that the court in NN Global was in error in proceeding on the basis that the arbitration agreement would not be exigible to stamp duty, the very premise of the order of reference would stand removed. The reformulated question sums the words which is not chargeable to payment of stamp duty and words unenforceable or invalid would therefore be as follows. Whether the statutory bar contained in 35 of the Stamp Act applicable to instruments chargeable to stamp duty under 3, read with the schedule, would also render the arbitration agreement contained in such an instrument as being non-existent pending payment of stamp duty on the substantive.
It's a correct reformulation of the question.
But
for the reason that the words which is not chargeable to payment of stamp duty is a hypothesis. So if you begin with the hypothesis that it is not chargeable to this payment of stamp duty, then what are you deciding? So what they decided, they just deleted that part, which was a premise. The premise was which is not chargeable to stamp duty.
Which, Milord, in my respectful submission, was the correct premise. It was the correct premise for this reason.
It can't be a premise. It's a question. It has to be answered.
But so far as, Milord, today the question is...
It is reframed as a question of law.
Yes, sir.
And that is the question of law which is sought to be answered. We'll have to Proceed on the premise of that question of law.
But my lord, if the correctness of the judgment is now under review by a bench of a larger
You want
bench.
us to reformulate the question of law itself in the same sentence.
My lord, I don't want your lordships to reformulate, but if the basis of this judgment is that it is chargeable to stamp duty.
No, it is not. That's not the basis of the judgment. But the basis of the earlier question was that it is not chargeable to stamp duty.
Which is correct.
But that's an argument.
That's an argument.
Probably your,
That's an argument.
probably your only contention is the question of law was, as framed was, if the parent contract, underlying contract is not properly stamped, will it affect the arbitration clause contained in that contract? That's your, that may be your contention.
But my lord, yes.
But they have answered it much bigger.
But my lord, so far as an arbitration agreement is concerned now, after applying the doctrine of separability, they have not separated the arbitration agreement and not said that under Article 5 residuary clause, it is now taxable under the residuary clause. Now, my submission for your lordship's consideration on chargeability is that when you are applying the doctrine of separability to a stamping
Sir,
circular,
Sagadende, how did the issue of chargeability arise at all? The question was the state in a proceeding under section 11(6)(a). Does the court go into the question of whether the agreement is stamped or otherwise? That was the issue. Whether arbitration agreements are per se subject to stamp duty or not really didn't arise, and it may depend upon the nature of the underlying contract.
but my lord, even then, even so, as a proposition of law,
Suppose the underlying contract is an agreement to sell immovable property,
that's it.
and together with it, just throwing an example,
With an arbitration.
possession is delivered. Now I know that, as a matter of fact, say in the Bombay Stamp Act, the Maharashtra Stamp Act, is treated for stamp duty as if it were a sale agreement.
Yes.
So it would depend very much on what facts are before you in that
But
case.
then I'm not saying that the main contract need not be stamped or should be stamped, or whether that can be gone into an A.
But should we go into it here before 7?
It will not, that would be required for this reason, that if I'm in a position to convince your lordship that an arbitration agreement which is made chargeable to stamp duty is based on a legal fiction which doesn't apply, because it's based on the doctrine of separability. The doctrine of separability, my lord, was evolved for the purposes of saving an arbitration agreement. If that fiction is something, my lord, which was created for that purpose, namely the arbitration
It
act,
will apply to the Stamp Act also.
it would not apply to the Stamp Act because it will not have an extended application. Now, if my lord, that legal fiction for which this legal fiction was incorporated in section 16, namely the Arbitration Act, if that fiction, my lord, has to be restricted for the purpose for which it was created, the stretching of that fiction to something outside the purpose is not permissible.
So the consequence would be then that the arbitration agreement would be treated as an integral part of the original contract.
Correct. Now after
In your
that,
submission,
in my submission, correct. Now, my lord, if that is so, let us, my lord, then say that it now, my lord, comes under one document with an arbitration agreement. Then, my lord, the provisions of section 5 of the Stamp Act would apply for the purposes of stamping. For the purpose of stamping the agreement, the arbitration agreement, not the main contract. Now, when we
No,
go
but
to section 5,
once you treat the arbitration agreement as not severable and an integral part of the main contract, then the entirety of the contract has to be stamped.
But my lord, therefore, that so far as that part is concerned, the arbitration agreement would also have to be stamped, provided it is a distinct matter under section 5 of the Stamp Act, not of the arbitration, of the Stamp Act. Would your lordship just have a look at section 5?
Of the Stamp Act.
Why you're raising the point? After Constitution.
My lord, may I just show your lordship first the Constitution bench, my lord, paragraph 88 to 90.
This is why you're arguing the point.
Which is why I am. If your lordship sees paragraph 88 to 90, page 374, paragraph volume 5A. It will always be. Paragraph 89. A perusal, may I read?
Yes.
A perusal of paragraph 29 would show Well, at 88, if you're not children. As far as the finding in paragraph 28 of NN Global, that the decision in SMS does not lay down the correct law when it holds that an arbitration agreement in an unstamped commercial contract cannot be acted upon or is rendered unenforceable. We are of the view that the finding in NN Global does not appear to be correct. A perusal of para 29 would show that the court in NN Global proceeded on the basis that the arbitration agreement, being an independent contract, is not chargeable to payment of stamp duty, and it would not invalidate the arbitration clause or render it unenforceable, since it had an independent existence of its own, cannot hold good in view of the admitted position before us that an arbitration agreement in its own right is exigible to stamp duty. Now, in para 90, the whole premise of the court in NN Global being that the arbitration agreement not being exigible to duty and it having a separate existence, the commercial contract in which the arbitration agreement is contained, being unstamped, would not impact the arbitration agreement, cannot hold good. The reasoning in NN Global in para 32 for disapproving of Garware in paragraph 22 thereof, that the arbitration clause would be non-existent in law and unenforceable till the stamp duty is adjudicated and paid on the substantive contract, is again on the premise that the arbitration agreement is a separate agreement under the Stamp Act, which is not exigible to stamp duty, which we have found is not the case in law. Now, my issue, my lord, is separate agreement under the Stamp Act is, my lord, something where the legal fiction, my lord, of separability, which is to be confined only for the purposes of the Arbitration Act, has been applied to the Stamp Act, and therefore, my lord, the arbitration agreement has been made stampable, which, my lord, in my respectful submission, is not permissible. No, my lord, if your lordships now turn to the Stamp Act for a minute. So this is the first reason why, my lord, the arbitration agreement is not subject to Stamp Act. The second reason, my lord, would be if you're on the reading of section 5, my lord just has a look at section 5. I'm arguing this today before your lordship because the premise of the Constitution bench that the arbitration agreement is stampable is, in my respectful submission, erroneous. Now, if my lord turns to section 5, which is at page 338, volume 4A, and then, my lord, I'll come straight away to the decisions on this. Any instrument comprising or relating to several distinct matters shall be chargeable with aggregate amount of duties, with such separate instruments, each comprising or relating to one of such matters, would be chargeable under this Act. Now, in order to not fall within the expression distinct matters,
so you have to cumulate the stamp duty. That's what this.
You would have to cumulate the stamp duty, but provided it is a distinct matter. Now, in my respectful submission, first of all, my lord, an arbitration agreement would not be a distinct matter because the doctrine of separability does not apply to arbitration agreements when it comes to stamping. The legal fiction cannot be extended. The second reason is that an arbitration agreement being ancillary to the main agreement
time study arbitration and then
Why do we have to get into this at all? Because, you know, the genesis of the dispute was whether in a 11.6a application you can look at whether it has examined whether the documents been properly stamped or otherwise. Should the power of impounding be exercised by the judge in the 11.6a stage? Now, for us to go into whether an arbitration agreement is at all stampable, we are saying it can never be stamped. We don't have facts. We don't have, for a bench of 7 to decide this question would be very, very.
Very well, then I.
Very briefly respond why it may be necessary to decide not this aspect but other aspects. We are concerned with 11.6a here, which is appointment of arbitrators by a court. But there's a vast body of appointment that takes place by individuals outside of a court. Every matter doesn't come under Section 11. Secondly, increasingly there is institutional arbitration. Institutions have to appoint. Again, they are not courts under 11.6a. It is perhaps necessary if your lordships to clarify that position as well. Not on the lines my learned friend is arguing. I disagree with what he's arguing. But it is necessary to set out the principle that all these matters
have to be decided by the arbitrator. There we are with you, Mr. Kamada, that we have to decide that issue. That what we say in relation to a court for a 11.6a application, you say would apply when an institution is appointing an arbitrator.
Or an individual.
That's right. For instance, the Delhi International Arbitration Center, when they, when you know, somebody moves the DIAC, you don't go into stamping. That will be decided according to you by the arbitrator.
Obviously, though, the judge bench has said that the Indian Stamp Act applies. I put it in my submissions. I'm not going to labor it. Actually, the Indian Stamp Act does not apply. It's the state acts that will apply because they are residuary clauses. But that's really doesn't arise before your lordship, but I put it only for clarity. The Indian Stamp Act won't apply at all because under entry 91 of list 1, the limit of what Parliament can do to fix rates of stamp duty is very limited. In fact, the residuary power is with the states. So the Indian Stamp Act doesn't apply at all.
I think
I'll leave it at that.
I think I'll leave it at that.
Stamp litigation in the states is on the local stamp act.
But I'll also leave it at that.
That's why they're normally on arbitration agreements as residuary arbitration.
Constitution de do.
100
Constitution de do.
Under the Indian Stamp Act, it is 4.5.
In contract, that's a different issue.
But
That was fairly false before the crisis.
the levy can have the preferential as a courts officer. Although not it was resulted in A state, but maybe subject to standard.
That's right.
The minority will not be able to apply that when you also come to a conclusion that it may be subject to standard, but it is fine unless NN one, NN global one. So this was wrong on that. So the interpretation of I am only in minority mode. Also look at this is a courts officer.
To as an agreement, if there is separate enactment, separate entry, it will be subject to that,
Whatever the state act provides.
whatever the state act will provide.
And most have, many have residuary clauses.
Maybe the residue, because it may be applying to the agreement.
So you are right. Sorry, go ahead, you're saying something. As Mr. Kambata said, entry 91 of the union list, which is what the Indian Stamp Act is referable to, says, in this book, page 472, rates of stamp duty in respect of bills of exchange, checks, promissory notes, bills of lading, letters of credit, policies of insurance, transfer of shares, debentures, proxies and receipts. That's the only remit of the Indian Stamp Act. Now see entry 63 of list 2,
Correct.
page 476. Rates of stamp duty in respect of documents other than those specified in the provisions of list 1.
So the residuary powers with the states, and your lordships have held so. In the Rama Sharma case, I've cited that in my submission. I'll just briefly place that for your lordships.
Because I think what we'll do is, I think I'll leave it at that. I won't labor this point anymore.
No, but what do we do about the finding of the majority then?
That's the reason.
Because on this, yes.
Both say that it's chargeable to
Both
stamp.
states have also said it may be chargeable because of that. No,
Any global one line said that Article 5, not of the stamp, of the schedule.
Of the,
Of the schedule to the stamp act.
No, section 5 may not apply. Section 5, when there is a mother contract, because section 5 applies if they are separate transactions in one document.
In one document.
It doesn't apply otherwise.
Which,
It doesn't apply mainly because subject matter is connected with some.
Let me address my words briefly on that.
no, no,
So leave it at that. We'll examine it in.
I was suggesting, my lord, to leave it to the facts of each case.
That will be decided.
On whether,
Paragraphs from the minority, where the minority also says this, it's 291, 292, 295, of Justice Rastogi's opinion, and 312, 412, 415
minority,
is, minority comprises of two independent opinions,
Yes.
of Justice Rastogi and of Justice Roy. Justice Rastogi's opinion is to be found in paragraphs 292 and 295, which would be EDF 436 of volume 5A. And Justice Roy's opinion, Roshas may kindly note not paragraphs 312, 412 and 415. 312 is at 442, 412 is at 478 and 415 is at 479.
and 312 is that page?
312 Lord is at 442, where they say that it's actually the court in NN Global 1 lost sight of Article 5 to the schedule of to the
Article
stamp,
5.
Article 5 to the of the schedule to the stamp act.
What does that say?
That contains a residuary entry saying that any other agreement not provided for will be subject to the stamp.
Yes.
that is the residuary article under which it is made stampable.
No, it may be taxable. It may be.
I was suggesting,
The presumption in the question as framed that it is not stampable is not correct.
That was
If
the
not
opinion.
otherwise
That
provided
was-
for.
that was-
If not otherwise provided
That's
for.
it. That's it.
And it says 8 annals.
So the majority in 5-judge bench goes by consideration of Article 5. Minority also takes Article 5 into consideration to say NN Global 1 was wrongly decided on that account, but holds otherwise on the mechanism.
Mechanism.
so my lord, I was
It
suggesting,
may be, in some cases, it may not be taxable.
That's
Where
correct.
it's not
Like
executed.
section 3 of the Stamp Act.
That is right.
No, not like section 3 of the Stamp Act.
Not raise the premise that it's not.
In all cases, it's not taxable.
That's right.
If it is not executable, if it's not been executed, because only on execution of the instrument that the stamp duty.
Not just that, Lord. Even section 3. Section 3 says certain instruments are not chargeable to stamp duty.
so I was suggesting, my lord, if your lordships could consider saying that so far as the stampability of an arbitration agreement is concerned, would depend upon the facts of each case.
That's right. That's good.
We're not going.
That's all. That's all. That's correct. That's it. That's all.
Facts of each case, and that's why, my lord, it should be relegated to the tribunal. Now, my lord, the next. And my lord, the submission is at page 29 of volume 1, where your lordship will find that. My lord, the next point is, short point, is that nothing can be said to be, of course, this has been made, my lord, by Mr. Daka, so I won't repeat it, but something which is rectifiable and curable, it's a temporary affliction.
Yeah,
It would
that's
not, my
covered.
lord, that's covered. My lord, that is at page 12 of my note. Then, my lord, the issue of section 5 of the Arbitration Act also has, my lord, been
He has argued
he has
that.
argued it that it's a notwithstanding,
Yes.
non-obstanding, non. I have taken up also, my lord, in my submission, the point of complete code, that an Arbitration Act is a complete code by itself, and therefore there is no question of the Stamp Act coming in. That's it. Just give me a minute.
Yes.
Part 2, but part 1 can't be worse off than part 2, because part 2 is on the basis of this. So, my lord, That would be my
Thank you, Mr.
submission.
President. Thank
I
you.
try to be.
Thank you, Mr. Mr.
Next is
Mr. Jain.
But your Worship would find my written note of submissions in volume 1 at page 30. I'll be briefer than Mr. Sakardande. Much of the canvas has already been painted. I do not wish to repeat any of the
Volume 1, page 30, right?
page 30. 30. But I have in my note referred to the paragraphs of the majority and the minority. But whenever if losses feel not any assistance can be taken from there. But I'm not reading or reiterating them. The points that I wanted to make are the following, and I'll try and elaborate it. The reason why we take exception to the formulation of the mechanism in which the stamp duty is to be collected, in the opinion of the majority of NN Global 2, what are the following? Not only does it not, in that classic sense, and please don't take me wrong on this, in that classic sense that it really relegates us to a position where, for want of a horseshoe nail, the kingdom is lost. In the sense, it compromises on all timelines that the Arbitration Act contains and gives us, namely, Losses will look at 11 subsection 3, subsection 13, where it says, within 30 days of the notice served to the other side, section 11 petitions to be decided. Section 9 contains a timeline of 90 days, and so on. Not all of this is a time-bound mechanism. That's one. And I'll leave this at that, because this is an obvious point, and I do not wish to carry court to Newcastle, because it is going to delay. And another reason for which we say it is going to delay is that under the Stamp Act, we have no mechanism of ensuring that it is in a time-bound manner. You just realize that. So in Garwari, you just directed the stamp authorities to ensure that the stamping takes place in a period of 45 days. We have no data whether the stamp authorities really respected that, but not given the manner in which the revenue authorities function, it is very likely that they did not observe that 45-day window. As a result of which, making section 11 petition hostage to an undefined timeline under the Stamp Act, and over which the section 11 court would have no jurisdiction, because the section 11 judge cannot direct the revenue authorities to do it in a time-bound manner or in a certain period of time. Why? Very often you may find that section 11 judge is not the same court as the court which would have territorial jurisdiction over the revenue authorities. Take, for example, seat and venue. Suppose an agreement is executed in Delhi, but has its seat of arbitration in Bombay. The Bombay High Court can't issue directions to the revenue authorities in the state of Delhi. And likewise. So you could have a situation where you have an uncontrolled timeline consuming an entire process. In other words, for want of a horseshoe nail, you have the kingdom getting lost. That's the point number one. The second point that we have for Roche's consideration is that this formulation also runs afoul of the larger public policy principle. The larger public policy principle that your lordships have seen in various legislations is that entertainability of a petition is not made subject to a fiscal precondition. I hope I'm able to communicate myself. Entertainability of a petition is not made subject to a fiscal precondition, except in situations where the legislature wants that to happen. And more often than not, those situations are in the instances of appeals. I have in my written submissions given examples, and if I may very, very quickly, without taking losses through those provisions, if I may invite your attention, my lords, to paragraph 2.4.1, my lord. Just kindly see that, not at page 33 of my written submissions.
That as a broad proposition may be very difficult to accept.
No, I'm just taking a leaf out of that. I'm not saying...
Yes, you can treat it as an argument to support.
That's right. That's the highest that I can put it.
Not as a...
No, of course not. I cannot not say that as a blanket rule, but I am giving instances where wherever the legislature found that there has to be a fiscal mandatory precondition. And for this, I assume that an arbitration agreement may be subject to stamp duty. But even then, section 11 contains no such formulation. And wherever, my lord, the legislature wanted, my lord, that fiscal preconditions to be, my lord, imposed, lordships would find that in those instances in 2.4.1, my lord, we have collated all of these, my lord, in volume. Sorry. 4C. Or volume 4C.
You're referring to central excise, surprise is excise.
That's right. And lordships would invariably find that those legislations use the word shall not be entertained, shall not be admitted. So, wherever the legislature felt that there has to be a fiscal, mandatory, inviolable, inexcusable precondition, the formulation is to be found in words like shall not be entertained, shall not be admitted, and so on. None of which are found in section 11. Not even found in 9, not even found in 8, and not found in 45.
So the formulas say in the Customs Act, the
That's
Central
right.
Excise Act.
And all of those are at the appellate stage.
Are crazy as well.
I'm so deeply obliged.
Appeal.
I'm so deeply obliged. And
only
all of
after
these
it.
formulations apply to an appellate stage when, my lord, there has already been an adjudication at the first instance. There is a finding of certain payments due and collectible, and then not that precondition is imposed. None of them provide at the first instance. And therefore, what it is not to say, because you are just counterbalancing the two acts. It's really a question as to, my lord, whether the Stamp Act should take precedence over the mechanism under section 11, or would your lordships leave the collection and adjudication of stamping and the duty, my lord, to the arbitral tribunal? It's a choice, my lord, between two competing legislations, and both of which are exhaustive courts. Stamp Act is an exhaustive court, and so is an arbitration. Both are consolidating acts. So therefore, in our respectful submission, the formulation by the majority falls foul, my lord, of this principle that where the legislature, and not this is also furthered in some sense by section 36 of the Stamp Act. Lord Lordships saw that Mr. Datar, Lord, in his own usual, Lord, illustrious way, but placed before Lordships not section 36 of the Stamp Act, which says once it is admitted into evidence, it will not be gone into. So legislature, while not making a fiscal statute, itself was cognizant that you can have some instrument slipping through the stage of evidence, and then there is no question of putting the clock back, going back on the admissibility of that instrument. That's why, my lord, neither section 33 nor section 35 invalidate an instrument. They only say it will not be received in evidence, but, and section 36 says once it has been received in evidence, there's no question of unscrambling, not scrambled egg. The third aspect, my lord, in our respectful submission as to why, my lord, the majority's view needs to be, my lord, recalibrated, my lord, is, my lord, that the majority leaves, my lord, Mr. Trivedi pointed out, my lord, section 9, the majority does not go into para 169 of the judgment. Majority says we are not going into section 9. Now, but in our respectful submission, that is neither here nor there, for the simple reason, an argument that is, I'm sure, not would be made before lordships, that section 9 should have a different test. But there is nothing in section 9 which gives any guidance to that argument, or which supports that argument. You cannot have a situation where, for the purpose of section 11, you have a formulation of a stamp duty first, entertainability later, for as purposes of section 9, a different regime. So, this is going to snowball, no, without a doubt, into a section 9 situation. This aspect of, first collect the stamp duty, get the certificate under 42, and then, entertain the petition is, with time, I'm sure, will snowball into petitions of section under section 9. Not section 9, as lordships have defined in numerous cases, is, are measures that are by definition
If something
urgent.
If something is void, then in section 9 will also come in.
Not that, no, I'm so deeply obliged for the question. It is an agreement can be void only within the four corners of the Contract Act. The Stamp Act does not invalidate a contract. It only says it shall not be acted upon or would not be admissible in evidence. It does not invalidate. And therefore, even for the purpose of section 9, my lord, the test of 11, with greatest of respect, whether it is 8, which says prima facie, 45, which is now brought at par with 8, says prima facie. the same test would have to be applied. And Lord Lodges have in Vidya Rolia held that the test for the purposes of 8 and 11 are synonymous. It's the same test that apply to 8 and 11. Lord, you just kindly note not the paragraphs of Vidya Rolia, Lord. Those are 144, 145, 147.5 in Vidya Rolia. 144, 145, 147.5. I will give the page numbers also, but kindly bear with me for a moment. Lodges would find Note 144 at PDF 189, 145 at PDF 190, 147.5 at 191 of volume 5A
Yeah.
of volume 5A. Now, Lord, that brings me to another point within this, the second argument that I have, that the larger public policy, my Lord, is to not treat the fiscal requirement as secondary, but surely not something that precludes the any party or any person, my Lord, approaching the court. Now, Lord, please have with me, Lord, unfortunately, that is in another volume. Please have with me section 149 of CPC. Of CPC. The Lodges would find that in volume 4A at page 727.
Volume 4A page.
727, Balam. PDF 727.
Seven to seven.
727.
727.
No, volume 4A, I'm sorry. Volume 4A, page 727.
4A. 727.
My loves have it now. I'm not. If a person does not go into the is not a party to an arbitration agreement, a suit would be the normal usual remedy. In a commercial matter, I'm not answering the description of a commercial relationship in terms of the arbitration. Right? Not if there is no arbitration agreement, a suit would be the remedy. For a suit, not the court fees will have to be paid. Please see how CPC deals with payment of court fees. 149, and kindly see the language. Where the whole or any part of any fee prescribed for any document by the law for the time being enforced relating to court fees has not been paid, the court may, in its discretion, at any stage, allow the person by whom such fee is payable to pay the whole or part as the case may be of such court fee, and upon such payment, the document in respect of which fee is payable shall have the same force and effect as if such fee had been paid in the first instance. Lord, a plaintiff moving the court under Form 149 seeks leave of the court to say, well, for reasons A, B, and C, please allow me some time to pay the court fees. That does not preclude Lord entertaining the suit. That does not preclude Lord the suit court from granting an interim relief. So, can we have an interpretation of the arbitration agreement, Lord, which puts a plaintiff in a civil suit in a better position than a petitioner under the Arbitration Act? Yet again, what Lodges find is the legislature saying there is a precondition, but it is not an inviolable precondition. We have ways and means of ensuring that Lord, in a given situation, ends of justice are met, while the fees can be collected later. Lord, we also have in the CPC Order 20, and by the 1976 amendment to the CPC, Plot 6A was brought into the CPC, Order 20, Rule 6A. Kindly have that plot. You also would find that at 793 in the same volume, volume 4A. I seek your Lordship's attention to sub-rule 2 of Rule 6A, my Lord. An appeal may be preferred against the decree. I'm sorry, not Lordship's heaven. An appeal may be preferred against the decree without filing a copy of the decree, and in such a case, the copy made available to the party by the court shall, for the purposes of Rule 1 of Order 41, be treated as a decree. But as soon as the decree is drawn, the judgment shall cease to have effect of a decree for the purpose of execution or for any other purpose. Once again, Lord, a decree would have to be stamped, would have to be drawn. But the legislature said you don't have to wait for expedition. For ends of justice, you can always have the decree being drawn in parallel, but the execution proceeds. Because it is not, we're not waiting. The legislature is telling us, please don't wait for a decree to be drawn, which would require stamping and proceed for execution. But yet again, another instance of the fiscal precondition, not for drawing of a decree being.
Many, Mr. Mehta, many such examples there. We are concerned with a very narrow compass.
That's correct.
Getting into other issues.
I'm just giving you examples where, Lord, the legislature has itself told us that a fiscal precondition is not such.
We are really confined now to interpreting this statute. So.
I'm not inviting it. My only purpose was to support my argument with Lord Order 22 Rule 6A.
Mehta, we look at your other submission.
I'm so deeply
Thank you, Mr. Mehta.
I'm most grateful, Lord, for a very patient hearing.
Thank you.
Deeply obliged.
Yes, Mr. Banerjee. And Mr. Khambata, we just wanted to know, I mean, it's entirely your choice. Would Mr. Khambata like to argue for, because as the amicus, you can wrap up what, unless you have all decided in advance, you know, who's going to.
Give me half an hour, Lord. Most of it is covered in the written submission, so I'm not going to whichever.
All right, Mr. Banerjee, you complete, so that we.
Lord, there is obviously a sense of deja vu here, my Lord, having argued this at some length, my Lord, before 5 judges.
And you're not springing any surprises on us.
No. I am, my Lord. I'm coming to the surprise in a minute. My Lord, this is the second time that there has been a 7-judge bench in an arbitration matter. And the earlier one was in this very court, my Lord, in 2005, in SBP, my Lord. The reason I'm mentioning this is that both matters concern an apparently innocuous provision of the law, which is appointment of an arbitrator, which is usually only to be brought in when the parties fail to appoint somebody, or the institution fails, or there is some stopgap required where the court has to step in, really just to make an appointment. Yet, such a matter has come before this court on 2 occasions before 7 judges. My Lord, it's why is a question that perhaps, my Lord, will require a long debate. But I will show your Lordships, my Lord, a little bit of the history of Article 11, which is relevant only to the question before my Lord, which is, it's a very narrow reference before my Lord. 11, Section 11, should the Section 11 court go into stamping? That's the only question, my Lord, which your Lordships have to see. Or should it be left to the arbitrator? Obviously, my Lord, the canvas is wide. My Lord, the problem is that while answering such an issue, every sentence that your Lordships utter in this 7 judges will have an impact on Section 11. That's the reality of the matter. My Lord, we have lived with SBP for 18 or 20 years. And even after the 2015 amendment, SBP, my Lord, the ghost continues. It was relied on in Garware, which is squarely before my Lord. And there is a very important passage in Justice Roy's judgment where he deals with, my Lord, SBP. That's one aspect of the matter. So far as, my Lord, the narrow question is concerned on 11.6a, my Lord, elaborate arguments have been made. I will, my Lord, I have in my index set out a structure as to how your Lordships can look at Section 11 and, my Lord, the consequences of stamping, that it is obviously, my lord, the agreement is valid and not void. This is a matter only of admissibility. All that has been argued. I will show a few pages of items which may have been missed. That's all, my lord. But, my lord, before I do that, I'll just take 2 minutes more of indulgence, my lord, because it's a mindset issue. My lord, judges normally, as I understand, I don't have any personal experience, whenever a matter comes before a judge, there is an inclination, my lord, to decide. If there is injustice and injustice presents itself and somehow there is an issue, the judge will decide. My lord, the entire purpose of 11 is somehow to impose self-restraint in not deciding. There is a Lakshman Rekha, my lord. If your lordship sees the language of 11.6a, the word used is confined to the examination. There is a Lakshman Rekha. There is a very limited scope in which the court, my lord, a section 11 court is really, and I said this before, my lord, it's really not a court. In fact, your lordships earlier would decide section 11 with a single judge. That was the practice in this court. That was the practice in the High Court. It would all be decided by a learned single judge. And in fact, there was a judgment of Justice Bharucha, as your lordships will remember, of 5 judges in Konkan, Chief Justice Bharucha as he then was, which said that really all you need to see is whether the procedure has been followed and appoint. And that, of course, my lord, did not find favor in SBP. So, my lord, the practicality of deciding something in a court in some way defeats section 11. My lord, the way the 2 acts are placed. My lord, we have grown up with the 1940 Act. The 1940 Act has a provision in section 20, where you appoint an arbitrator with intervention of the court. Your lordships, you may remember, long time ago this section was there. There the thinking was, at the very first instance, the court will intervene and the court will decide what is the scope of the reference, and all points would be decided at the section 20 stage and go on. My lord, the 96 Act is a complete about turn. Nobody is saying, my lord, this is something, my lord, which haunts judges. Nobody is saying that the court will not have the final say. The court has to have the final say. The last word, supervisory jurisdiction, has to be with the court. Arbitrators cannot be allowed to run riot. But, my lord, we are not at the last stage. We are at the first stage, at the appointment stage. So, who has the first look and who has the second look? What has happened here, my lord, is instead of the first look being with the arbitrator at the section 16 or article 16 stage, slowly and slowly, 11 jurisdiction is being, my lord, slowly and slowly, my lord, increased. And the burden is immediately coming on the court. And the whole purpose was that the burden should not come on the court. Any matter your lordships take of 11, whether stamping or otherwise, your lordships will issue notice, somebody will file a reply, they will say limitation, they will say this, that. Lot of court time, my lord, is taken. And the entire purpose of taking it out of the system on day 1, which the institutions do. My lord, they appoint, it goes out. 16, you have your first shot. 34, you have your second shot. And ultimately, the court decides. So, my lord, please keep this larger picture in mind, because every sentence your lordship will say on section 11, 11.6a will have some impact, my lord, broadly. Every sentence, not only in re-stamping, will have. This is, I wanted to, my lord, make this submission at the first instance. Now, my lord, in this slide, I will just show the index to my written submissions and only show a few aspects that your lordships may consider. Please come to the written submissions, my lord. The written submissions start at page 45 of the first volume. My lord's got the index. My lord, this, I've just put it in a structure, and most of these arguments, my lord, have already been made. 4 or 5 aspects I just want to highlight. My lord, first is the introduction. How did the reference come about? What were the findings in NN Global? What is the relevant issue framed, my lord? Then, my lord, what are the summary of the submissions? I'll place them at the end. Then, my lord, the Stamp Act. the relevant provisions, which Mr. Datar has mentioned, the relevant authorities. Now, my lord, here Hindustan Steel was mentioned. There are some very interesting judgments, my lord, Privy Council, High Court and the Supreme Court. I will come back. He is Stamp Act versus an Indian Contract Act. That also has been addressed in some detail, my lord, 2G, 2H, 2J. What I would submit are the errors. Then, my lord, Roman 4, international perspective. I want to develop this. I want to show, my lord, what is the basis of this article and how it directly impacts, my lord, this stamping case. Then, my lord, Arbitration and Conciliation Act at page 46, my lord, what is the history? What are the relevant paragraphs of the 246 law report? What did the high level committee say? And then, my lord, some judgments. And then, my lord, Roman 6, I have focused on Garware and United India Hyundai, because, my lord, that has been specifically affirmed by the Constitution bench in paragraph 29. And, my lord, Vidya Drolia, actually now it has been clarified, and I have mentioned it in my written submission in Career Institute, that really the question was not there. My lord, your lordship will see that one page before I go back, my lord, on my note. Your lordship just sees the Career Institute reference. Please come to page 108 of the written submission.
How long are your written submissions?
Sorry?
How long are your written submissions?
Well, I thought that it is better to put everything down so that since we are, my lord, pressed for time, I have put everything down in writing so that it is there rather than only giving pointers. Please come to 107. I mentioned, my lord, Careers Institute, Educational Society. This judgment, my lord, this order came one day before Vidya Drolia. Had this come, perhaps, my lord, there would not have been any need to debate Vidya Drolia to great length. Sorry, in NN Global. So, my lord, this order had not come, then the judgment was delivered one day later, and it has, the scope of Vidya Drolia has been, my lord, explained in Career Institute. I am therefore, my lord, not going to really touch upon Vidya Drolia today. My lord, I want to just show my lords Garware, because nobody has, yet your lordships have not seen Garware, which is the sheet anchor decision on the basis of which the 5-judge, my lord, proceeds. So, if your lordships are pleased to just see Garware. Lord, Garware is at page 33, volume 5A, my lord.
5A.
5. My lord, Garware is absolutely on the point where this court holds that at the section 11 stage, stamping is required. That is, my lord, the 2-judge bench. My lord, the reasoning in Garware, your lordship will just note the paragraphs 18 to 22 and 29 in Garware. 8 to 14 is the history.
18 to 22
and 29. My lord, these are very important. If your lordship starts with paragraph 8 to 14, that starts at page 46. Lord, 8 to 14 summarize the previous history, Konkan, Rani, SBP, and then, my lord, quote the Law Commission, etc., and the bill. And, my lord, it summarizes everything in one place. My learned senior, Mr. Datar, referred to paragraph 13, which has the statement and objects and reasons. But in one place, my lord, everything is being summarized. 8 to 14. The reasoning starts at paragraph 18, which is at page 54. 18 to 22 is the heart of the reasoning. It will be noticed from the aforesaid judgment that where an arbitration clause is contained in an agreement or a conveyance, different consequences ensue depending on whether the agreement or conveyance is unregistered or unstamped. Then the next sentence. it is settled, again, my lord, SBP comes back in the picture. It is settled by SBP and Co. that Section 16 of the 96 Act has full play only after the arbitral tribunal is constituted without intervention of court under 11. My lord, this is harking back to the previous regime of intervention in court, intervention of the court, intervention without the court. My lord, this finding at paragraph 18 proceeds on the basis that SBP is good law, that moment something is decided in 11, the 16 jurisdiction, which is really, my lord, the wider jurisdiction of existence, validity, jurisdiction, is curtailed because a court, and no court, my lord, the Chief Justice or his designate, because that was SBP, has decided something in a mini trial finally. So how dare an arbitrator go behind a Section 11 order in a Section 16 situation? Now, that is the impact of the quote of paragraph 12, which is quoted in some detail here. And, my lord, in that quotation of SBP, which is relied on by the two judges at page 54, if your lordships come to 55, somewhere in the middle, my lord, prima facie, your lordships have this, this is relevant because of, my lord, the model law commentary. Prima facie, it would be difficult to say that in spite of the finality conferred under subsection 7 of Section 11 to such a decision of the Chief Justice, the arbitral tribunal can still go behind that decision and rule on its own jurisdiction or on the existence of an arbitration clause. So, my lord, what SBP says is, because 11.7 says the decision of Chief Justice is final, 16 jurisdiction is curtailed, 11 binds the 16. Now, my lord, that is the basis on which, if your lordship sees, at the next paragraph, where is that one? Para 22, my lord, the finding on this aspect. No. Lord, sorry, please come to page 56. In view of the law laid down by the 7-judge bench, it is difficult to accede to the argument made by the learned counsel on behalf of the respondent that Section 16 makes it clear that an arbitration agreement has an independent existence of its own, must be applied while deciding an application under Section 11. So, my lord, the 16 argument that all issues should go to the arbitrator is rejected in view of SBP. This is first finding. Second finding, my lord, 19, my lord, the finding is the Law Commission has not specifically referred to my lord SMS, but it has overruled, my lord, it has legislatively overruled SBP. Then, my lord, 20, then 22 is the second error, which is the para which has been confirmed by the division bench, which your lordship, constitution bench. Please come to para 57, page 57. When an arbitration agreement is contained in a contract, it is significant that the agreement only becomes a contract if it is enforceable by law. No difficulty. We have seen how under the Stamp Act, an agreement does not become a contract, namely that it is not enforceable in law unless it is duly stamped. Now, this is the error which has been, my lord, compounded by the constitution bench. Therefore, on a plain reading of so and so and section 2H of the Act, 2H, my lord, is set out above, which is, my lord, 2G and H have been set out, would make it clear arbitration would not exist where it is not enforceable by law. This is the second error. And the third error, my lord, is at 29, where Hyundai comes in. That's the third aspect your lordships may consider, which is at page 62.
Page
62, running page 62. Here, my lord, the division bench relies on Hyundai. To say, my lord, this was a Scott and Avery clause case. I'll just read it. The judgment in Hyundai is important. What was specifically under consideration was an arbitration clause which would get activated only if an insurer admits or accepts liability. Since on facts it was found, insurer repudiated the same, though an arbitration agreement exists, so to speak, in the policy, it would not exist in law as was held in that judgment. When one important fact is introduced, namely insurer has not admitted or accepted liability. So, my lord, this is the understanding of Hyundai. There's a problem with Hyundai because Hyundai is, there are difficulties, my lord, which I've highlighted in my note. The clause is intact. It is just that the scope is limited to quantum and not liability. We can't say that the
Hyundai is
arbitration,
accepted, then accepted.
it's an accepted matter to the, so there's a problem with Hyundai also. Likewise, in the facts of the, likewise in the facts,
Look at section 11.
so, my lord, in fact, what happened in Hyundai, my lord, I put it in my notice. The learned single judge of the Madras High Court, she appointed an arbitrator, saying that this should go to arbitration. This honorable court, my lord, following a pre-11/6A judgment, held that no, there was no dispute as to, there was a dispute as to liability. Hence, the matter should, my lord, rest here, and the 11 was dismissed. So, my lord, again, the problem there is that, so I have dealt with that in my written submission. What, on the basis of Hyundai, which is now affirmed by the 5 judges, and Justice Roy Malott takes the opposite view. On the basis of Hyundai, this is the third part of the ratio of this judgment. Likewise, in the facts of the present case, it is clear that the arbitration clause that is contained in the subcontract would not exist as a matter of law. To summarize on Garwade, my lord, 3 points on Garwade. One,
Just 1 second.
my lord, it resurrects SBP to curtail the Section 16 jurisdiction. It resurrects SBP, my lord. Section 16 jurisdiction is curtailed basis SPP and relying on Section 11.7. This is one. Two, my lord. And that is a point which has been developed in great detail by Mr. Datar. Two, it holds a non-stamped agreement to be non-existent in law. And three, my lord, it relies on Hyundai, which itself has its own, my lord, problems because it was an accepted matter case. It was a 3-judge bench, and my lord, there are issues with that judgment, and I have, my lord, spelled it out. Just to decide Hyundai, your lordships, there had to be numerous hearings. First in the Madras High Court, then it came here, then that was heard. So, my lord, this is exactly what is the entire idea is to take it out of the court at the first instance and push it to the arbitrator, and of course, my lord, ultimately supervise at the 16/30. So, my lord, this is so far as Garwade is concerned. My lord, Hyundai, I have said whatever I have to say. My lord, I will now go to just 2 pages on this issue of existence in law and stamping, and then, my lord, the foreign jurisprudence which has not been shown, and then I'll, my lord, sum up. My lord, 2 pages in the written submissions, your lordships will see, and something quite interesting. Please come to page 61. 59. This is following on from what Mr. Datar has already argued in respect of the Contract Act. That what is the intersection of the Contract Act and the Stamp Act? The lordships at page 59, Hindustan Steel, my lord, that has already been mentioned. Then at the bottom of 59, there is a mention, my lord, of the Privy Council, which affirms the Patna High Court. Page 59 of the written submission. Your lordships got 59? Volume 1.
Yes.
Titled Relevant Authorities. My lord, first there is Hindustan Steel, which was mentioned in the morning. Then, my lord, at the bottom of page 59 is the Privy Council and the Patna High Court judgment, which, my lord, I have quoted. Object of the Stamp Act is not to alter the terms of the bargain between the parties, protect the revenue by excluding proof of the bargain. This is so far as this is concerned. Then at page 60, my lord, there are a series of judgments which consider the Stamp Act in some detail in the context of validity. And out of these judgments, my lord, the second one, Gulzari Lal Mewari, all these judgments were considered by Justice Roy in his dissent, noted in the majority but not considered. Gulzari Lal Marwadi is important because what the judge there finds is that in England there are provisions which make where non-stamping actually makes an agreement void, unlike in India. So, my lord, he gives that example in Gulzari Lal Marwadi. Then, my lord, Purna Chandra Chakravarti, Justice Bijan Mukherjee's judgment. And then, my lord, the most interesting one, which is the bottom of page 60.
The Pakistan.
The Pakistan one. My lord, I will, it is very elaborate, but I will not read the judgment. He goes into the legislative history of section 33 and 35 from the 1890s and sets it out. But, my lord, I am not on the judgment so much as the judge. The person who delivered this judgment was a Parsi judge called Dorab Patel. He was destined to be he was their H.R. Khanna. He was destined to be Chief Justice of Pakistan. When Zia-ul Haq came to power, he was asked to take an oath of office. He refused and he resigned. So he could not become Chief Justice of Pakistan. In the Bhutto reference, three dissents, one of his main dissent was authored by Dorab Patel. So very learned man, barrister, he analyzes in great detail the interplay. This case, what had happened was, there was an insurance contract. In that insurance contract, which was unstamped, the matter went to an award. The award was sought to be enforced. The argument was made that, look, the initial document is unstamped, it is void. He said that cannot be the law, that is a valid document, and there are some very interesting passages, some purple prose, if I can put it, where he uses very colorful language and he analyzes this. And your lordships will certainly read this judgment if only for that and for the background. So, my lord, the consistent position in all high courts, in the Privy Council, everywhere else is the fact that mere payment of stamp duty, my lord, does not invalidate the bargain. In fact, the way he puts it is, my lord, the object of the legislature was to protect public revenue and not to interfere with commercial life by invalidating instruments vital to the smooth flow of trade and commerce. And then he said it would be against all canons of construction to enlarge the meaning of the words in 35 so as to render invalid instruments which fall within the mischief. So, my lord, if the majority view in NN Global is to be sustained by this court today, forget arbitration. Anybody can turn around and say at any point that this agreement is void, this agreement is invalid, I won't do anything, whatever benefit I've got. In fact, my lord, we had also cited before the 5 judges a Privy Council judgment, my lord, which explains that if you take this sort of extreme view, then there will be all sorts of, my lord, practical difficulties. And Mr. Datar mentioned the quotation, my lord, from Mullah. We had also cited, my lord, the 13th Law Commission, where this problem was addressed. I'll just show, my lord, that passage from the 13th Law Commission, which is mentioned in the note itself. Presided over by Mr. Setalwar, where he deals with this particular issue specifically. Lordships will just see page 64 of the written submission. '64, my lord, refers to Mahan Singh, which is the Privy Council, and then Lord, please see page 65. This very question was raised about unenforceability. This very question of stamping and unenforceability was raised and shot down, and the law was summarized. My lord, at page 65, all these documents, my lord, are on record. We've given the volume and the page where it is there. The above judgment was relied upon by the Law Commission in its 13th report, chaired by MC Setalwar, specific context of an unstamped agreement, while dealing with a recommendation as regards section 2G as follows. Director of Legal Studies has also made the suggestion it should be provided in section 2G that agreements of imperfect obligations are not void but only unenforceable. He has mentioned an unstamped agreement as an instance of such a case. Such an instrument, which is a record of an agreement, is neither receivable in evidence nor can be acted upon. See section 35 of the Stamp Act. Since the decision of the Privy Council in Mahan Singh versus U. Babi, which I have quoted there, the law is well established that the expression unenforceable by law, which is what is in 2G, does not mean unenforceable by reason of some procedural regulation, law of limitation, but unenforceable by reason of substantive law. In view of this, it is unnecessary to introduce the suggested change. So, my lord, 2G is restricted to unenforceable by law, which, as is explained, is void. So, my lord, if an agreement is void, null and void, that stands on a completely separate footing. My lord, we are not going into existence or validity here. My lord, we are on admissibility. So, my lord, this is so far as this aspect is concerned. In this background, I would like your lordships now, just before, my lord, I come to the summary of my submissions, to just see the model law and the commentary, because that has some, my lord, impact on this. So, my lord, the model law, Article 11 of the model law was basically incorporated by us in section 11. And your lordships will recollect, I mentioned it a little earlier, that SBP seems to suggest in the majority and is disagreed by Justice Thakkar in the minority, that because 11.7 says a decision by the Chief Justice is final, that means nobody else can look at it in 16. But the intention actually in the model law was exactly the opposite. This expression final and no appeal has been explained. There are two commentaries on the model law which are of relevance. One is a book by Peter Binder. We have put the extract. Peter Binder very conveniently collects all the foreign law on each of the articles. And there is a second book by Holtzman and Newhouse which we have put, also extremely convenient, because the entire discussion as to the Trabo is set out in Holtzman and Newhouse. I know my learned friend Mr. George Pothan has individually set out the entire thing, but these two books actually summarize the entirety. And I will just show 4 pages of that.
Where is that? Where we refer to these two?
The first one, if your lordship sees Peter Binder is in volume 4B at page 4393. I hope I've got that right. Serial number 7. Volume 4B, 4393. Interestingly, today I'm citing the 4th edition. The 2nd edition was cited in SBP, but not noted. 4393. Has your lordship's got 4393? International Commercial Arbitration and Mediation in Ancestral Model Law Jurisdictions.
4393.
In fact, your lordships will find there is not much case law, because nobody other than us has a problem in appointing arbitrators. And there's a reason. Your lordship's got 4393? Yes. Well, 4394 is where the model law is set out. Please see Article 11.5, because this will become relevant later. A decision on a matter entrusted by paragraph 3 or 4 of this article to the court or other authority specified in Article 6 shall be subject to no appeal. This is where we get our finality provision from. The court or other authority in appointing them shall have due regard to qualifications. So, this is the source of our 11.7 of finality. Now, why did this come is made clear, my lord. If your lordships go down a few pages to 4398. It starts at 4397, default procedure, 4398, paragraph 6. Two very interesting sentences at the bottom of 4398. The finality of a court's or other authority's decision in this case is essential to the rapid constitution of the arbitral tribunal, as was pointed out by the analytical commentary. I'll show the analytical commentary. The next sentence is even more interesting. It is suggested that this provision does not infringe on the procedural rights of the parties because the possibility of applying for setting aside of the award according to Article 334(2)(a)(4) of the model law remains open. So finality, the purpose of finality is really to make sure that the procedure starts, because the arbitration should start. Then, of course, the court has the right. paragraph which I was reading, you know, please see the Act. Your Lordships are very familiar with the Act. My Lord, in 8 there is an appeal. In Section 8 there is an appeal. In 9 there is an appeal. In 17 there is an appeal. Even in 16 there is a part appeal. In 34 there is an appeal. In 45 there is an appeal. Only in Section 11 is it that there is a specific no appeal. And the reason is, my Lord, for this reason. Because in every other situation, the court, my Lord, is a 2-1E court. In an 8, your Lordships will have to apply mind as to whether it is a suit which has to be stayed, what are the prima facie grounds, etc. 9 is interim relief, there has to be some prima facie case. 16 jurisdiction, if it is, my Lord, allowed, there is an appeal. 34 application of mind. 45 there are some grounds. But 11, the statute says, 11.7 of our statute says no appeal. And the reason is this. Finality, my Lord, is in the context that you get the cart rolling. So that 16, my Lord, there is a lacuna in our statute that in the model law, there was an appeal from 16. The reason why there is no other jurisprudence of any consequence abroad, and my Lord, I'll show that, is because all these issues, stamping, this, that, everything goes to 16. There's a straight appeal in 16 before the 34. So you don't have to suffer the whole arbitration. But that's, my Lord, a legislative lacuna which may perhaps be addressed, my Lord. So, my Lord, this is the passage here. Finality is essential to the rapid constitution, and then, my Lord, there's a footnote. The footnote refers to the analytical commentary, which I will show. And the suggestion by Peter Binder is the reason that this does not fall foul of parties' rights is because you have a later challenge. Justice Thakkar in his dissent uses the phrase chronological priority. My Lord uses the first look and second look. First look with the tribunal, final, second, definitive look with the court. Nobody is running away, my Lord, for that. So, my Lord, this is one passage I want to show. The second one is the, my Lord, in this, if your Lordship goes one more page at 4399, cases clout. So, all the cases under the clout system, Article 11, my Lord, and there is not much law because this is really not debated. This is not a problem. This is a problem peculiar to our Act and our jurisprudence. So, my Lord, those cases are there. Please leave that. Please come now to the relevant portion of the travaux préparatoire, the model law. My Lord, please come first to page 4363, same mantra. 4362 is my Lord, the title. This is, everything is in one place. A guide to the ancestral model law on international commercial arbitration, legislative history and commentary. Howard Holtzman and Joseph Neuhaus. My Lord, this in the next page gives the article. I don't want to, my Lord, read the entire thing, but it is essentially a default clause. It's a stopgap. Please come to 4386. 4386. Seventh Secretariat Note, analytical commentary on draft text ACN 9/264, 25th March 85. You know, this has been separately annexed also, but it is here. And in this, would your Lordships come to para 7, which is at page 4387. This is, my Lord, what is quoted. Rules and guidelines for decision of court, paragraph 5. According to paragraph 5, the decision of the court shall be final whether it relates to a matter entrusted to it by the court by the suppletive rules of paragraph 3 or by the mandatory provision of paragraph 4 in cases where an agreed appointment procedure fails to secure the appointment. Finality seems appropriate. These are the words which again take us back, in view of the administrative nature of the function and essential in view of the need to constitute the arbitral tribunal as soon as possible.
As you said, to get the cart going.
This is to get. So, the entire purpose of Article 11 was only appointment of arbitrator and leave everything else by and large to the 16 jurisdiction. So, my lord, this is the international, this is the basis on which we have our 11.7, which uses final and no appeal. Same, my lord, the same portion is used in 11.7. So, my lord, this is something that your lordships may keep in mind, because in Gadware, the two-judge bench specifically refers to that portion of SBP, and on that basis curtails 16 and says that 11 has a wider play. So, my lord, it squarely applies, and this aspect has been dealt with by Justice Roy in his dissent in 4 paragraphs, which I will show, my lord, and then I will just summarize my submissions my lord, in 2 pages. Your lordships may just see the dissent of Justice Roy on this aspect. Earlier portion. No, on SPP. Page 492.
Volume number?
Of volume 5A. Just your lordship, just give me a second.
What page?
492.
492.
One. Not that. Right at the beginning.
Para 455.
Yes, Mulon may come to page 458.
458 or paragraph 458?
458, Mulon, of Justice Roy's
Paragraph or page number?
page number. Page. Volume 5. 5A, my lord.
458.
5. My lord, 5A, 457, he is discussing SBP, and 458, my lord, he starts discussing the dissent at para 353. And he gives, my lord, he summarizes Justice Thakkar's dissent at 354. Firstly, the function of the court is to interpret the provisions as it is and not to amend, alter, or substitute the interpretive process. Secondly, it's for the legislature to make a law applicable to certain situations contemplated by it. Judiciary has no power entering into legislative wisdom. Thirdly, as held by me, the decision of the Chief Justice is merely a prima facie decision, and subsection 1 of section 16 confers express power on the tribunal to rule on its own jurisdiction. Fourthly, it provides a remedy to deal with situations created by the order passed by the arbitral tribunal, emphasis in original. Then one sheet anchor of his decision is in the guise of interpreting statute, judicial legislation not permissible. And then 355, he then considers section 16 in some detail. And then 356 is the conclusion in the dissent. The above line of reasoning in Thakkar J's dissent resonates with the internationally recognized principle of competence and the doctrine of separability. Majority opinion SBP suggests section 11 could conduct a mini trial at the pre-referral stage, which is where, my lord, we are heading again. Jurisprudential correctness of SPP has been doubted and was considered as excessive judicial intervention. It has been legislatively overruled by subsequent amendment. So, my lord, he finds SBP is gone, and there are a number of observations thereafter. The majority still and the concurring jurisdiction of Justice Ravi Kumar still relies on SBP. Garwade still relies on SPP, my lord. That ghost is still there. Because, my lord, we feel, or judges feel, that where there is some injustice, even at the 11th stage, there is a, my lord, inherent desire to correct the wrong. But in correcting that, my lord, wrong, what the balance is, that wrong could equally perhaps be corrected by somebody else without taking up. Well, today 7 judges are sitting on an arbitration matter which really should be somewhere else before somebody else deciding a 16 on stamping. So, my lord, that was my lord, what the dissent, my lord, specifically affirms. So, my lord, these aspects your lordships may keep in mind while laying down the parameters of 11 in its totality, and in particular 11.6a, which is the language is, my lord, absolutely clear. My lord, another interesting thing. In the majority judgment, in the 5 judges, there is no place where 11.6a is quoted. Confined to the examination of the existence of the agreement, each word has been paraphrased, analyzed in great detail by Justice Roy. That expression, that provision is not quoted in the majority at all. So, my lord, whether on the text or the context, admissibility issues at least should not be touched at the 11th stage. Now, my lord, in that light, I just want to conclude by reading or placing 2 pages of the written submissions which summarize whatever, my lord, there is. Please, there it is summarized in various places. Your lordships will come to page 54 of the volume 1 written submission. It's just 2 pages, my lord. I'll just place it. 54 in volume 1. Anything else? The majority view in NN Global, the unstamped agreement is void, does not exist in law, does not lay down the correct law. Such a view is contrary to the provisions of Stamp Act, settled jurisprudence. In so concluding, majority judgment failed to deal with the several authorities cited before it, including, my lord, all these authorities which I mentioned, stating that an unstamped agreement does not render it invalid or void. Then, my lord, 2 is it is a fiscal enactment, it is not a weapon of technicality. 3, my lord, I have taken from the judgment of the Supreme Court of Pakistan. Object is to protect public revenue, not to interfere with commercial life by invalidating instruments vital to the smooth flow of trade and commerce. 4, my lord, it's a curable defect, merely prescribed document from being admitted into evidence. 5, my lord, again, does not affect the validity of the transaction, merely renders the document inadmissible. 6, my lord, is important. Parties which have acted upon contracts substantially perform their obligations under such contracts insufficiently stamped will be visited with severe, drastic, and unduly harsh consequences. If an unstamped agreement is deemed to be not existing in law and or to be void, particularly true in cases original agreement is not traceable. Then, my lord, 7 is widening of the scope of arbitration agreement. Then, my lord, page 55. 11.6a language confined to the examination of the existence. Investigation to aspect stamping contrary to the plain language, contrary, my lord, also to the statement of objective reasons, which says please don't go into other issues. Then word confined has a specific meaning, my lord. This was quoted by Justice Roy in his judgment, that it's a Lakshman Rekha, you have a limit. Then, my lord, what I have submitted is existence has a specific meaning, should be restricted to existence and validity at the highest of the arbitration clause. Validity would mean arbitration agreement not null and void. It should be restricted to formal validity at stage of contract formation. Inquiry should only be to satisfy agreement in writing for contractual ingredients fulfilled. And in any event, 12, by no means should it be extended to whether document is inadmissible as being unstamped. Inadmissibility and invalidity, my lord, whichever way we look at it, are different legal concepts. Lack of stamping is admissibility. And then, my lord, I mentioned 2015 amendment, and it is not turning a blind eye because, my lord, the arbitrator can look at it. And 16, even if your lordships under 11 appoint an arbitrator, the section is clear. 33 and 35 make it clear. Arbitrator is an authority under 33. He can look at it. He is looking at it, my lord, in all institutional arbitrations, in all other ad hoc arbitrations where there is consent. As an arbitrator, I have also been confronted on the first day with an unstamped agreement. One has to sort it out in whichever way possible. And, my lord, ultimately, there are a lot of 2 and 3 judge benches. Sometimes it is difficult to reconcile them, but your lordships have the luxury of sitting in 7. And if there are some portions that can be ironed out, I would request, my lord, this is an opportunity. After 18 years, my lord, it is not often that one gets a chance to raise an arbitration issue before a forum, and every sentence of my lords in the context of appointment of arbitrator will have some impact. It may be that 2019 amendment may be notified. It has not been notified as yet, but there is some rethinking on some aspects. Ultimately, whatever your lordship say will have an impact not only, my lord, and I'm making, and I think I can make bold to say, not only on the stamping aspect, it may have some impact on other section 11s. And I conclude by, my lord, mentioning a judgment of my lords, which shows that there are 11s pending from 2006, 2010, 2012. And my lord, the reality is it is really like a mini trial. You file the application, other side comes, he files a reply, you file a rejoinder, then there is a full-fledged hearing in the High Court, then there is an SLP, then your lordship sometimes, and the reality is that out, and we made this calculation, maybe in 8 or 10 matters, my lords have closed the 11. In the vast majority of matters, their appointment has been made and the matter has gone on. So, Lord, it is also a question of balancing judicial time and the legislative, Lord, intent, and keeping it out of the system at the first instance. Nobody is saying it will not come back. Everything somehow at the 34th stage or somewhere may come back. But, Lord, that's the larger issue. So I am deeply obliged.
Thank you, Mr. Banerjee. Yes, Mr. Kamlata.
Okay, my learned friends would leave me about 45 minutes, but they seem to have left me 5 minutes.
But Mr. Kamlata, we can give you a little time tomorrow. Not
Yes, if your lordships are kind enough for that. But I will of course not repeat anything, and I want to also place before your lordships a perspective not only under Section 11, but also private appointments of arbitrators and institutional appointments. Because I think, as my learned friends have said, 7 judges do not sit often to hear an arbitration matter. It's best that these matters are also ironed out by your lordships, because otherwise, my lord, other matters will float up the stream to your lordships subsequently. There's no point in that. Your lordships are fully seized of all the issues. It's best that your lordships lay down the law emphatically now. But I think Justice Khanna actually encapsulated the issue before my lords when all is said and done. And I believe Justice Khanna said whether non-stamping or understamping of the main contract can render the arbitration agreement void or invalid. That's really the heart of this debate. And I would request my lords to hear my arguments with 1 or 2 overarching thoughts, my lord. The first thought is that ultimately the Stamp Act is a means to secure revenue for the state arising from the stream of trade and commerce. The Arbitration Act assists the stream of trade and commerce, and any roadblocks at the initial stages will only dry up that stream. So to use stamp as a gateway dispute to arbitration really defeats the purposes of both acts. Today we are talking about making India a global hub for arbitration. And we have before us Section 5 of the Act, which has already been shown to my lords, as well as the fact that the Arbitration Act is a complete code. And I think taking all these together, I want to first give your lordships 3 reasons why the issue of stamp must be left to the tribunal in the first instance. There is always a 34 court, there is always a second look. And as my learned friend said, the first look, should it be just a prima facie look? Should it be a look at all? Or should it actually decide the matter at the outset? Now, there are 3 broad reasons why I commend, my lord, that your lordships purposively interpret the provisions of this Act to hold that the matter must be left to the tribunal. The first, and I'll go through it very briefly because my lords have expressed some view on that already, is the doctrine of separability. I'm conscious of the fact that under Section 16, that doctrine is incorporated for the purpose of the tribunal deciding its own jurisdiction. But it's not only under Section 16 that we find the doctrine of separability under our Act. We have it in black and white in Section 7. My lords, just see Section 7 for a moment. 7 subsection 2, which draws the distinction between an arbitration agreement, which may be in an arbitration clause, and the main contract. Lord, may I continue tomorrow?
Half an hour to 45 minutes tomorrow.
I'll can complete. We'll be here at 10:30. With great questions.